This podcast is brought to you by the School of Advanced Study, University of London. All of our podcasts are available from our website, www.sas.ac.uk.
Well, first of all, thank you to AB Colombia for the invitation to be here, and thank you all for actually being here towards the end of the day. I think it's actually very impressive that people have managed to stay throughout this entire period. I'm sure it's been fascinating talks all throughout the day, but to think that we could actually hold your attention towards the end, I think it displays a lot of optimism, so I'll do my best. So as Alan was mentioning, I work for Lee Day, which is pretty much the only firm in the UK that has brought a number of cases against British companies for allegations of human rights abuses taking place all over the world, including in Colombia, also very recently in Peru, in Nigeria, in South Africa. We really are looking at the operations of British companies wherever they may be, and trying to assist communities who have been affected by those British companies to have their claims heard here, mostly because they haven't been able to get satisfactory responses in their own states. I've been asked to talk about, we've all been asked to talk about human rights due diligence and accountability in practice. And it's an interesting topic because in many ways what we're having to do is think about what human rights due diligence may be in practice, but in some ways postulating as to what that may be, because a lot of the time it's quite hypothetical still. But what it's all based on, obviously, is this discussion about the guiding principles that John Ruggie came up with in his role as a special representative to the Secretary General of the United Nations on business and human rights. And I think Guiding Principle 15 really encapsulates what this panel is looking at, which is what is due diligence, and what does it mean in practice to the extent that we've been able to see anything in practice. But then what is the link between that human rights due diligence and accountability? Guiding Principle 15 sets out due diligence, the responsibility to respect in terms of having a policy commitment and then implementing a human rights impact assessment effectively, even though that term is not necessarily the one used throughout the guiding principles. It is very much what underpins the integration part of what happens after you've got a policy commitment. So as to try to identify what the impacts might be, prevent those impacts from being realised, mitigate them if they are realised, and then account for how those impacts are addressed. And similarly, within this framework, there is a call on companies to have remediation processes. The commentary describes this process as being essential as part of business enterprises knowing and showing that they respect human rights. And I will come back to that knowing and showing aspect. One of the things that I'd really like to, I suppose, leave you with as a message is that from my personal point of view, I think human rights due diligence does have potentially a very important role, but there are a lot of limitations to relying solely on human rights due diligence when we're talking about accountability. And one of those limitations is to do with, well, what is the scope of what that human rights due diligence would look like? To what extent would a company adequately assess its potential impacts? This issue of context, so that the circumstance in which a company might be operating, is one that I don't think is very fulsomely dealt with in the guiding principles. I think what we'll find is that if you look at the guiding principles, and it's not necessarily nighttime reading, you might find it a bit dense. I read through it again last night, and I can tell you it is quite dense. There's a lot of information in there, but in terms of context and what it means for a company to operate in conflict zones, for example, is quite thin at the moment, and it is an area that does need fleshing out. What it does say in Principle 23 is that conflict-affected areas may increase the risks of enterprises being complicit in gross human rights abuses committed by other actors. And while that's undoubtedly true, I think that it's important to sound a word of warning, which is that when contemplating the types of activities that business might be engaged in a conflict zone or in an area that is prone to conflict, so not excluding informal conflicts, and not only focusing on areas of war or official conflicts. It's not just about whether or not a company might be complicit in the gross human rights abuses of others, but actually how that company's own presence, how its activities might affect that conflict, and how that business's activities might not only have an impact in terms of exacerbating existing conflicts, but might be used by one side of the conflict against the other, and how that may then impact on the rights of those who are completely vulnerable to their rights being abused in that context. And I think we had a very short discussion about this issue in the last session. At what point does a company start thinking about, well, even though we as a company don't intend to have a role in this conflict, to what extent does their human rights due diligence include an assessment of whether it is at all appropriate for them to be engaged in that circumstance of conflict? So I think this issue about the scope of human rights due diligence is one that still really needs to be fleshed out. Certainly one of the things that I wanted to focus on is also the issue about human rights impact assessments, and what does it mean when we're talking about the actual implementation and integration of those impact assessments. Human rights impact assessments have not been around as a concept for so long, but environmental impact assessments have been around for a very long time. And they're required in a lot of circumstances, including in the circumstance that Alan had mentioned, which is the BP Colombia case that my firm has been working on for quite a number of years. And in that circumstance, basically what we've got, which is the Flores and Equion Energía case, which was formerly BP Exploration. What we had there is basically a situation where in 2005 there was a case brought against BP, which actually was fairly quickly wrapped up because the company saw that there were a lot of lapses in the way in which they built a pipeline that runs for about 450 miles across remote parts of Colombia, and the impacts of that pipeline on local communities. A second round of litigation was started in 2008 for other people who hadn't actually been compensated in that first round of litigation. So this litigation, which started in 2008, involves about 73 farmers who claim that basically the way in which this pipeline was built has contributed to soil erosion that has had concomitant effects in terms of their ability to use their land, to grow crops, to rear their cattle, to get clean water. And that has actually prevented them from being able to continue their subsistence lifestyle, to ensure that they've got crops and cattle for sale when necessary. And it has led to significant food insecurity for the families involved. One of the things that is certainly alleged in this case is that the environmental impact assessment that was undertaken was entirely inadequate. While it was required, the way in which it was undertaken was, as we allege, entirely inadequate. And so that has meant that the way in which that impact assessment ultimately led to any change in the way that the company operated was very limited. Now, if we postulate that at the time they ought to have done a human rights impact assessment, you can see the potential for, despite requiring a human rights impact assessment, it potentially not preventing the types of circumstances that we've seen in this one. If there had been a human rights impact assessment, it ought to have, for example, considered what would the impact of this pipeline be on, for example, the rights to food, the right to family, the right to adequate standards of living. But simply the requiring of an EIA is not going to, or a human rights impact assessment either, is not going to necessarily prevent the types of situations that we've seen arising. Interestingly, in this case, very recently we've actually also added in a claim for daños morales, meaning moral damages, effectively, under Colombian law. And what that's seeking is compensation for the emotional distress, pain and suffering of having this issue of food insecurity being one that the families have had to live with. So you can see from a litigation perspective and from a liability perspective, from a company's point of view, they ought to do this type of human rights impact assessment well, so as to prevent these types of claims having to be made, because potentially they can be made. Another issue I want to raise is that I think it can be quite dangerous to assume that the whole issue of human rights due diligence being for companies to know and show their impacts on human rights, I think fails to recognise that it's not always the case that human rights abuses occur because a company hasn't known or it hasn't shown or wants to show that it has this human rights commitment. One of the cases that we've worked on and which settled successfully last year was the case of Tabara and others and Monterrico Metals, where the communities brought a claim against Monterrico Metals for what we alleged was their involvement in torture carried out by the police at the Monterrico Metals campsite. And I don't think it's in anyone's mind the potential for this having had not occurred if the company had undertaken a human rights impact assessment. This sort of circumstance doesn't require a human rights impact assessment. It ought to be known from the very outset that having a number of individuals captured, brought by the police or your own security to your campsite and tortured over a period of 2 to 3 days is in no sense of the word respectful of human rights. You don't need human rights due diligence to understand that that's just simply wrong. Now, mind you, the company will of course say, well, we weren't responsible, and they did. They denied liability. But this sort of example exemplifies why human rights due diligence is not always necessary, and how carrying out human rights due diligence doesn't necessarily prevent the types of human rights abuses that can become the subject of litigation. The second example of how that knowing and showing is not necessarily the issue actually relates to the claims that we've got against Anglo-American South Africa. Now, it's interesting that Anglo-American is pretty much the only company that has actually come to this discussion. And it is important that Anglo-American is starting to really look at its human rights impacts and so on. These cases that are up there on the screen are actually about the way in which Anglo-American South Africa operated in South Africa for decades. In circumstances where they operated the gold mines, and we are representing, in the UK, over almost 2,000 claimants, in South Africa, 18 claimants, who are all bringing claims against Anglo-American South Africa for having failed to protect them from a disease known as silicosis, which has been known about in the industry for well over a century. So this is not an example of a situation where the industry didn't know that the illness existed, it didn't know of the dangers, it didn't know how to prevent it. The reality is that profits were obviously an imperative. And this is another example, I think, of why it's not essential to rely on human rights due diligence in order to prevent these types of circumstances. The company need not have undertaken human rights due diligence to prevent these types of impacts. And I don't think that this is really just a matter of the company having not known that those human rights impacts were a likelihood. I've only got a couple of minutes, so the last thing I wanted to say about human rights impact assessments was just this issue that they can at times be inconsistent. There can be inconsistencies or conflicts between what's demanded of a company from its home state, for example, and what the reality is for people who are living on the ground who may not actually want a human rights impact assessment undertaken. And the example, I think, of this is really the gold corp mine in Guatemala, where shareholders in Canada insisted that Goldcorp undertake a human rights impact assessment of its operations in Guatemala, partly as a result of the extensive criticism of the company's operations in Guatemala. And yet, a lot of the community members in Guatemala were actually opposed to the idea of having a human rights impact assessment because they saw it as a way of potentially just ratifying the continuing activity of the company. They didn't want the company, or a lot of people didn't want the company to continue its operations, and by having a human rights impact assessment, it was potentially just letting the company continue, but maybe in a different manner. Even that human rights impact assessment report, which was criticised by a number of groups, but even that report acknowledged that the assessment process itself appeared to be making worse the tensions that existed on the ground. Now, just very quickly, because I've only got, I think, about a minute, but it is a fairly important part of this discussion, which is the remedy side of things. Now, you'll remember from the Principle 15 that I put up that the remediation process from a corporate angle is an important part of it. But there are issues, I think, to do with the extent to which corporate grievance mechanisms are in fact accountable. To what extent is it possible, for example, for a company to fail to balance the existing imbalances of power between communities and the company, when the company itself is actually in charge of the grievance mechanism. There is certainly an issue about what role should legal advisors play. If community representatives have access to legal advisors, should they be excluded from being able to access a corporate grievance mechanism? Now, the principles talk about corporate grievance mechanisms should not preclude people from being able to access judicial remedies. But I think the reality is we'll find that, and we are finding, that companies will actually preclude people from accessing those mechanisms if they're also trying to pursue a claim through the courts. One question I think which was very interesting and raised very recently by Professor Ruggie was to what extent the corporate commitment to respecting human rights goes out the window as soon as litigation starts. And he raised that in the context of Shell and its challenges to the extent to which the Alien Tort Claims Act is in fact valid in the United States, and whether or not it's attempting to effectively throw out the baby with the bathwater in making those arguments. The Chevron Ecuador example is another good one of the extent to which corporate commitments to human rights seem to very quickly be discarded in litigation. And this issue of relying very heavily on legal separation of powers, separate liability when it comes to litigation. The role of states can't be emphasised enough. We've had a bit of a discussion about the Legal Aid Sentencing and Punishment of Offenders Bill. Unfortunately, it is having a regressive impact here in the UK, or will have that sort of impact in terms of allowing people to access the UK courts. Some recommendations up there which I will leave and give you 2 seconds to read them, and perhaps we can pick it up in discussion. Thanks.